Hello guys, welcome to my video. In this video, I will explain leading maritime lawyers. I have a series of videos which I made for this topic that will help you in any cases. For example, if you ever met a car accident, motorcycle accident, catastrophic injuries, or any other type of injuries which comes into the circle of accident, a road accident. So if you like my video, then also do share to help others. Let's begin. Our Houston, Texas maritime injury attorney have won over 10 billion. Houston Maritime Attorneys, we serve injured maritime workers nationwide. Offices in Texas and Louisiana. Just like any other industry, seamen are at risk for suffering work-related injuries anytime they are on the clock. The courts recognize this and are continually working to protect injured seamen through general maritime law. Maritime law gives workers who have been injured offshore or in the maritime industry the chance to claim necessary compensation for any offering for medical complications. The following acts are foundational to maritime law: Jones Act, Death on High Seas Act, Limitation of Liability Act, Longshoremen and Harbor Workers Compensation Act. General maritime law is the basis for all injuries sustained by seamen. It is important to have a comprehensive understanding of the general law before delving into the subsequent acts. Free maritime case review. You need the best maritime attorneys to handle your case. Contact us today. Here you will write your first name, your last name, your email, your phone, or your new client. Tell us about what happened and send a message. This is a free maritime case review. Case results: 357 million largest workplace accident settlement in Texas history. Arnold and Itkin LLP secured a massive nine-figure settlement against a transactional corporation for workplace incident. The settlement set a Texas record for being the largest personal injury settlement in the state history. At Arnold and Itkin, the whole company is selfless amazing. It meant a lot to me because I don't think I could have made it through without them. I was very happy with the outcome of the case. Very happy. Joe, workplace explosion victim. History of Admiralty and Maritime Law. Maritime law, also referred to as Admiralty law, is nearly as old as shipping industry itself and governs most accidents that occur on navigable waters. The law's roots can be traced back to the unwritten customs of the nautical behavior of the Egyptians and the Greeks. However, the earliest formal codes were established around 900 BC on the Greek island of the Rhodes. The original maritime laws and the codes stemmed from an accident outcomes and the rules of shipping. For example, the doctrine of general average, the concept that all the sea cargo stakeholders, owner, shipper, etc., evenly share any damage or losses that may occur as a result of the volunteer sacrifice of the part of the vessel or cargo to save the whole, can be traced back to earlier shipping customs of the Rhodians. The concept of the separate legal authority regulating maritime issues was brought to the West by Eleanor of the Aquitaine, who learned of the concept when she accompanied her first husband, King Louis VII, France to the Mediterranean on the Second Crusade. The term Admiralty law came from the British Admiralty courts, who presided over maritime matters separately from England common law courts, as the US judicial system is based on the British system. Amended Admiralty laws were gradually incorporated into our legal systems soon after the Constitution was ratified. Though still based on industry standard and customs, maritime law is largely found in the US Constitution, treaties, and the international conventions. Federal statutes and the general maritime law and the other judicial decisions, administrative regulations, and customs. When does maritime law apply? Perhaps most obvious, maritime law applies to events that occur on high seas. In other words, accidents that happen beyond the territorial waters of any country. Furthermore, maritime law applies to the territorial area which has water within 12 miles of the shore. However, the law applicability becomes less clear further inland. Early in the United States history, maritime law did not apply to incidents that occurred within the body of the country, and therefore excluded incidents involving the Great Lakes and the non-tidal island waterways. However, throughout the 9th century, this exclusion eroded away. Maritime law is now applied to the navigable waters. A waterway is deemed navigable if by itself or by uniting with other waters. It can serve as a continued highway over which commerce is or may be carried out on with other states or foreign countries. Consequently, if a body of water is completely landlocked within a single state, then it is not navigable for purpose of admiralty jurisdictions. However, a body of water does not need to be flow between states to be deemed navigable. Body of water may be deemed navigable if it is a link in a chain of bodies of water that can be used to service interstate commerce. Ultimately, the test is the commerce of one state must be capable of being carried into another state or foreign country. Once this test has been passed, it is likely that maritime law will be applicable in this case, even if it's a recreational vessel. Instead, that required Texas maritime accident attorneys are here mentioned. So this was all about my video. Do like, subscribe my channel, and spread among people for their advantages which will help them you and others. Thanks.